Well, may I permit to mention restoration application upon notice to the other side.
Yeah, my lords, kindly mention one matter. This matter after taking leave.
Ajay, sir, we want to tell you one thing.
My lord.
You please inform Mr. Shahadai. Tomorrow at 2 p.m. Earlier we fixed that matter for hearing. But our primary matter is going on. It's not a regular bench. So tomorrow we won't be taking up your matters. So if you can please inform your other side and intimate Mr. Shahadai.
I will intimate.
Let this be finished. We will fix a date and we will take it up. Yes, what you are mentioning?
There are some urgency. I have taken leave to move this application without certified copy. But urgency is that I have challenged the virus of the 2024 control order. Learned single judge has disposed of the matter, referring that since the issue is pending before the division bench, we will not interfere with the though hold in
Which division? Ours.
your division, your lordship's
Oh,
division.
that virus of that.
We have not challenged the virus that learned judge are in by saying that there are some urgency. You will also kindly fix a date.
When you have given the returnable date?
But returnable date has already been over.
Are you mentioning upon notice?
Yes, upon notice I am mentioning.
Let us see.
But there are some urgency. Group 8 matter. There are some urgency in this matter. If you will also kindly give some precedence.
Because tomorrow, day after, we will be taking up.
Day after, any day, any day.
Let us see whether it can be taken up next Monday.
I'm grateful.
Monday kimba Wednesday.
Well, may I permit to mention a matter for inclusion?
What you are mentioning upon notice? Give a notice and comment tell us. Yes.
My lord, that habeas matter, lordship was kind enough on the next available date matter will be, my lord. Tomorrow there is a bench, my lord.
Let us see, we will arrange something. When we sit with
Lord.
Justice Ritoproto Mitro, we shall fix the matter.
Tomorrow a bench is there in the.
So I don't know what is the position. If it is possible, we will give, otherwise no.
The Union of India has filed, my lord, one SLP lying pending defective.
Let us see.
Deep level.
May I have your lordship's kind leave, my lord, to mention a matter for.
When is that SLP fixed?
No, my lord, it is remained defective. They are yet to cure the defect. Because of unless, my lord, contempt court, my lord, otherwise they will not move it, my lord. Possibly this is the strategy.
Yes.
May I have your lordship's kind leave, my lord, to mention a matter for inclusion, my lord.
Are you mentioning upon?
Yes, my lord. Yesterday night only, my lord, through email, my lord, has sent it.
Is this application?
My lord, appeal, my lord, is having, my lord, 3 applications, my lord.
Appeal hearing
My lord,
or application?
My lord, application. My lord, on the last occasion, my lord, the respondents, my lord, paid for time to file affidavit in opposition to my section 5. My lord, the time was granted and my lord, leave
Now
was
what
granted.
happened? Have they filed?
No, my lord, they have not filed. Therefore, my lord, I am mentioning. My lord, 2nd September was the last date. My lord,
Give this.
May I be permitted to mention for any date fix for any date the matter is assigned to your lordship
Assigned to which bench?
on the order dated 28th August.
কোন bench assigned?
বেঞ্চটা কি বলো না কোন বেঞ্চ অ্যাসাইন হয়েছে
Decided by মানে
বলো না
Pilot presided over your lordship.
পাবলিক ইন্টারেস্ট লিটিগেশন আমি কি করব? পাঠিয়েছে? কোথায় পাঠিয়েছে? Where is your notice to the other side?
I have notified all the respondents.
Not always, and that you are mentioning today. Have you given a
Yes,
notice?
I have given the notice. The letter is on.
Let us see when.
Lordship, may I be permitted to mention one matter? Lordship, mentioning for inclusion in the daily list.
Are you mentioning upon notice?
No, Lordship. I will serve by today, Lordship.
Give a notice and mention. Yes, call the list.
But the outset, my lord, I must thank Mr. Maiti and Mr. Sen. At their instance, my lord, all registration done.
Oh, you will not thank us.
I have come to
The matter which is otherwise not mentionable, my lord. We have learned that court should not give thanks.
Huh?
But I am for the read petition or appellate. Yes, I'm coming now. In the year, my lord, rule 1969, my lord.
School did not appear in the reach petition.
No,
Yes, what you
my lord, I'm coming. In the year 1965, my lord.
no, what interim order you want?
Yes, I'm staying of the order, my lord.
What stay?
Yes,
Your
Lord.
petition has been dismissed.
Yeah, that
So
is.
your stay application will be hard upon exchange of evidence. That much you can prove. There is no scope for any interim order. Have you annexed all the documents?
Yes, I have.
Evidence which were exchanged.
No,
No.
summarily it has dismissed.
Not but telling Next.
advocate undergot ভুগড়োবহন বেড়াইছে
Pilot, item number 4 and 5. I appear for the respondent college. But I'm led by Mr. Kolal Basu. He is, my lord, out of station due to some difficulty. My lord, I'm paying accommodation only for the day.
I'm for the appellant in both the matters, Your Lordship. I'm led by Mr. Priyankar Shaha. He's also due to some
Yes.
grateful, Your Lordship.
4 and 5. I
4 and 5.
Both.
Yes, next.
6 and 7, my lord, I am for the
I'm for second board, Your Lordship.
6 and 7.
7.
Both are analogous matter.
Analogous matter. My lord,
Individual service.
one mistake was created by the learned advocate. My lord, in item number 7, private respondent is not made a party. If your lordship kindly grant me leave.
Was there in the
Yes, yes. My lord, in first appeal, my lord, item number 6, private respondent was made a party. But in the second appeal, item number 7, private respondent is not made a party. But your lordship kindly grant me.
My lord, I am appearing the respondent petitioner, my lord.
parties upon them is also not complete.
No, my lord, that's why I am.
Why both matters?
Why to my lord, petitioners filed a writ petition challenging the suspension order, and private respondent, that is first appeal, private respondent filed an application, writ petition, challenging the appointment of the petitioner.
So very good. Now in the first, in this number 6, you have served.
Yes.
Then nobody is appearing.
No, my lord, I am appearing for the respondent, but item number 6 does not serve upon me, my lord.
You are appearing.
Respond,
Item number 6, you are appearing for whom?
respondent petitioner, my lord. Respondent petitioner, my lord, was a Bowry.
Kanailal Badwi was the private respondent.
No.
Yes, sir.
Kanailal Badwi is not the private respondent. My lord, yes, one of the writ petition, he is the petitioner. In WPA 21217. And Bhogirath Badwi, he is also a petitioner in WPA 5039.
Well, there is a two writ petition, but I filed one writ petition being WP number 5090.
First petition, is there any defect?
No, no.
First appeal.
First appeal.
Number 6. There is
Item
no
number
defect.
6, no defect. মানে private respondent is also a party. But in item number 7, private respondent is not a party. Like your lordship kindly grant me leave to add this way and
Because-
have served copy upon my learned.
In your first matter, 6,
Yes,
how many private respondents?
only one.
দেখি, 6 নম্বরের ফাইলটা দিয়েছো?
One person has been appointed, my lord. Second man, he has challenged.
6টা বর্গের মানে পেয়ে
আলাদা আলাদা নেবেন
Oh, in this matter there is a defect. There is a defect. You have not given the name of the school properly.
Yes, I know. And also my lord, he not made a party.
পরেরটা
আমরা কোন আছে
তুমি তো আমাকে 5 আমি নাই 5 না পরে সার্ভিস করে না আমাকে 5 সার্ভিস মাইনাস
7. Respondent number 7. 2 to 3 করে দিই। Before that, my lord. Before that, party to my client because that in respect of WPA number 21217.
in the first matter he will remove the defects. Matter will come up after 2 weeks.
Mr. Banerjee, learned advocate, appealing for the appellant.
Explain that.
Yes, yes.
Further
Yes.
এই তো এখানে আছে আপনি আপনার কপিতেই আছে
Met with issue, Lordship. But I have for the appellant writ petition. But these
for the state laws led by Mr. Bishas.
are the state. Lordship, the appeal, my lord, has been preferred. My lord, challenging the judgment and order dated 17th of July 2025, where, my lord, the writ petitioner has been, my lord, initially, my lord, come before your lordship for non-grant of increment in his favor. So, my lord, that was because of the reason for. I'm sorry.
সার্ভিস করেছো তো?
হ্যাঁ।
কমিশন তো আসেনি, ওরাই তো আনসারিং রেসপন্ডেন্ট। শুধুমাত্র ছিল বলে ট্রায়াল করে তোমাদের
আচ্ছা।
আছে জানি না, সার্ভিস করে দিয়েছি। ইনিশিয়ালি ও দাঁড়িয়েছিল, তুমি দাঁড়াও নাই, ডিসাইডেড ও দাঁড়াচ্ছে না কেন? বলে দিচ্ছি।
তো সার্ভিস
বলতে
পেমেন্ট হয়েছে 24 জুলাইতে অ্যাকাউন্ট বন্ধ দিয়েছিলাম, জয়েন করতে গেলে তুমি ধ্যান দিকে ভুল আবার জানেন যে অ্যাকাউন্টমেন্টটা 6 মাস লেট হয়েছে, বেনিফিটটা পাই জানুয়ারি থেকে পাচ্ছে, ওটা হোল্ড করে দেয় ফরচুন খারাপ। জানুয়ারি 25 তারিখে জানুয়ারি 26।
এটা ওইটা ঠিক করে এটা চাইছিস তাই করছি জানুয়ারির মধ্যে অ্যাপয়েন্টমেন্ট পেল,
ঠিক ওটাই পাইনি, রাইট। ওটা কি ডিসাইডেড? দিয়ে দিচ্ছে, দিয়ে দিচ্ছে, ঠিক অবজারভেশন।
But this, my lord, the fact of the matter is, my lord, that I
joined on 9 January 25. Initially, you could have joined in November 23. So November 24 should be counted as your date of appointment.
lordship, but this issue is,
You have said that you give it as a special case.
my lord, yes, this is my prayer before your lordship. I tell your lordship, my lord, this similar point has come before this honorable court. Before I take your lordship to that, my lord, my lord, Rule 10, my lord, says that if I complete 6 months of service as on 1st of July of the next year, my lord, then only I am, my lord, entitled to get the increment. So, my lord, that I am, my lord, being deprived of the reason of the School Service Commission. But here, the judgment, my lord, that I handed up to your lordship, kindly sees paragraph, I'm sorry, page number 6, my lord, the operative portion, my lord's order comes.
ডেট অফ জানুয়ারি
So had you been appointed in November 25,
Yes, 24.
how could you have completed 6 months?
My lord, I would have to complete, my lord, 6 months as on 1st of July of the next year. So, my lord, I will be completing the 6 months.
December, could you have covered 6 months?
Absolutely, my lord. Had it been even 31st of December, I would have done. My lord, it would have been, my lord, 31st of December, I would have completed 6 months.
জানুয়ারি থেকে জুনে 6 হয়ে গেছে, জুলাইতে 7। হ্যাঁ, নভেম্বরে করলেও কমপ্লিট।
সমস্ত
appeared for the state.
Lordship, it is means this cannot be an instance, Lordship, because every time someone will be coming a mistake. Lordship, that is true, but
Your lordships are directed to treat him notionally,
Yes.
and when from the date it.
on 1st July.
Yes.
1st July,
Yes.
notionally.
Only for the purpose of incentive, nothing else. Lordship was already directed.
একটা অর্ডারের কপি আমায় দিয়ে দিও।
And my lord, they have complied with this as well. My lord, sorry. The state.
Short passover back. 6 months. Number 18. I was a read petitioner. Mr. Bishas, Bishru Bishas.
Short body. It will delay আছে।
Mala, yes, there is delay.
So 16 দিন। Have you filed application?
Yes.
With copy?
Yes, copy has been served.
You are not opposing the delay?
No, my lord, actually, my lord, Mr. Bishas is coming, my lord. Kali short pass.
ও তো আসবে। Are you want opposition to the section 5? So tell us what was the main matter. Tell us the story.
Regarding higher scale of pay. Yes, madam. Page.
You are for the read petition.
Read petition. The state has preferred this app, madam.
তাহলে you can opposition to the section 5.
Well, opposition. Yes. No. Today I want to first time. This is first time. Section 5 allowed.
Are you opposing the conversion?
Yes.
আছে শুক্র তোমার সঙ্গে কাকে নিয়ে
State is just
ঠিক আছে।
section. You have filed contempt application.
Yes,
Yes, my
pending.
lord, they have filed contempt
Pending.
application. And they are proceeding with the contempt.
No
application.
specific ground is there, my lord. From the date of communication, my lord, total departmental proceeding, only
That
LR,
order, my lord,
LR
is
to
complete.
have.
That order was passed in a different, complete, my lord, different perspective. My lord, that order was passed in that case had the petitioner, my lord, obtained the decree, my lord, before the school service commission, my lord, came into effect, my lord.
This has added finality.
Yes.
Have you seen the Justice Stanton's order after the special bench?
My lord.
তো দিয়ে দিয়েছে তো। After the judgment, Calcutta, Justice Stanton has given the benefit to
Bokul Singh's judgment. And thereafter, following the judgment of those two judgments, Justice Mantha's division bench also, he appeared.
My lord, I will go through this order, my lord, let it appear on the next day, my lord, I will go through those.
And now,
Where is Justice Mantha's order?
yes, I have. Well,
Was the issue in Shobhi after School Service Commission Act, physical education, that in Shobhi was granted.
yes.
Tarok, what happened?
In Tarok, it was reversed.
Was reversed. Then was it sent to any higher bench?
Yes. Larger bench, Utpal Karan.
Oh.
In the meantime, appeal preferred before the Honorable Supreme Court also tagging all these matters.
Appeal preferred with tagging which matter?
Chovik, Saidullah, as well as my lord Boishali. Boishali also physical education teacher.
Boishali was accepted.
Accepted. Chovik accepted.
Shobik was accepted. Boishali
Yes. Paragraph 262
Where is
of the judgment.
That is
Utpal Karan. Now, appeal preferred before the Honorable Supreme Court. It was pending. Honorable Supreme Court formulated 4 of the grounds.
Those 4 grounds were answered.
Answered by the Honorable Special Bench. Allowing the only physical education teacher because of the fact following the Boishali's guideline, since in respect of the
Para 170 he says Shobik is good law.
Shovik, yes, in respect of the physical education matters only. There are 2 types of. Yes, categorically, it was paragraph 255 it was. In respect of physical education. Well, I had the occasion to appear on behalf of the Boishali. And our argument.
Created is, so after Utpal Karan, what is the position?
Position in respect.
That there is no, it is not a legal right.
Right. But
physical education you can give.
Correct. Because
the others are concerned, it has to come staff pattern
and my lord, other ROPA rules amendment will be followed as on the date of entry in the service. If one past graduate, nothing. If one honors oblique postgraduate in terms of those 3rd June 2002, 4th 11/2004, those notification subsequent amendment of ROPA 98 to be covered. Everything has been answered. But in respect of physical education, since there is no separate group, one has to go by the Bokul Singh. Yes, Bokul Singh. দিচ্ছি দাঁড়াও না But page 3, that is Bokul Singh, following the larger bench.
Justice Manthur.
No, justice standard judgment.
Page
3 of that compilation. Kindly see. Yes, following Bokul Singh as well as the larger bench, my lord, kindly take the judgment of Justice Mantha at page.
Justice Tendon's judgment. Where is that paragraph?
Yes, paragraph, my lord, quoting paragraph. Kindly read first paragraph 2. Fact. SSC. Yes. Now, my lord, kindly take page 9. Where Mr. Bari had the occasion to appear for the state. My lord, it has been clarified. And thereafter, paragraph, kindly sees paragraph 6. Physical education teacher to the higher pay scale upon acquiring higher qualification has already been decided in 3 judges bench such and such, reported in such and such. A copy of the WCRC such and such. It is further stated the clarificatory correction in the special bench has also been made by a coordinate bench in FMA 538 means Bokul. 538 FMA টাই বকুল, এই তো বকুলের জাজমেন্ট এইটা, paragraph 2 and paragraph.
Research cleared on 18th.
My lord, I know this. I know this.
Section 5, your opposite.
Yeah, I have.
If it appeared on
18.
Want to use any affidavit using the name.
All right. All right. All right. All right. I shall try. I shall. Because
So you short affidavit in opposition.
ডিলেশনে কন্ট্রোল হয় আর স্টেটে আমরা ইয়ে দেব।
in respect to the section
For further consideration on 8
yes. Now, no, this is in respect of other subject. In respect of Boishali or physical education, 1998 recruitment rule says something. Here says only physical education here. There is no pass oblique honors. Therefore, they are entitled to. That is why Boishali. My lord got my point. In those notification recruitment first, EDN probably 40.
No honors.
Yes.
No, that is because there is no honors.
Honors course. That is clarificatory in Boishali.
Master's course.
Master's course. Correct. So that is why physical education teacher is entitled to, in terms of the recruitment itself.
Now, after school service, the subsequent amendment law is said that a person who has got honors category upon enhancement will get.
Yes.
And in physical education, there is no such provision immediately.
Yes.
It has
Having degrees, MPH degrees,
if he doesn't have a degree, on the date of enhancement he will get.
obliged to yours.
All laid down.
Obliged to yours.
But in respect after 1997, who has got graduate skill and took the job, he will not get even after enhancement of
Enhancement of other subject in terms of those amendments.
get. Upon enhancement he can get.
Get.
So if he is appointed in the past category, he cannot get, even after enhancement.
If he is in past category,
Yes, madam.
even after enhancement he cannot get because he has to appear again.
Appear.
Yes, madam.
Yes. Because there is a distinct two subjects. But physical is exempted.
I'll be directed to subjects, we have to compile this so that I can go through and.
Twice given. Twice given. Twice given.
Never, never.
এই তোমাকে দিয়েছি জাস্টিস মান্তার ঘরে পুরো দিয়েছি তুমি ফাইল বার করো মান্তার জাস্টিস মান্তার that is why I am giving update.
Please give us, you have
Shovik. Yes. My lord, I have the one copy. May I get it Xerox? And or I am checking it. If there are other copies, report it. Yes, Tarok I am giving by half an hour.
Then do one thing which
Two copies I am giving.
Yes, those judgments you make and annex.
All right. I shall by half an hour I am giving.
No, in course of the day.
In course of the day. And if your lordship
And if you show that you have seen before,
Today we are not.
I am calling him. এটা আমি দিচ্ছি আমি দু কপি দিয়ে দিই and for your lordship's desire I have prepared one compilation in respect of the larger bench in which paragraph in which pages for sorting it out so that I can find it out at a glance each and every point discussed.
you have done after we have completed.
Yes. 18 আমি সব দিচ্ছি সব দেব
লোক মিস্টার বাড়ির শেষ
he appeared in that matter also.
Or we can dispose of Mr. Vani.
No, madam, let it appear on next day. Let it appear on 18th, madam. Your lordship directed to appear on 18th.
And your DSC has passed.
Let me go through that.
One, you talk with your DSC. They don't file unnecessary litigations. Law is settled now. If your state government now ventures and come repeatedly,
I will.
he is bound by him.
He's the DI. He's not the highest authority.
DI na DSC commissioner. He was called on to the court.
I guess DI has preferred this appeal.
No. In this case also, whatever it is, that in identical issue has taken a decision. So state if wants to file a bill, what is the expenditure of
Director may take the plea. We have allowed that prayer on compulsion because there is a contempt and there is a personal appearance. That we have allowed.
No.
He may
This is
take
not
that
the plausible logic. This is not the plausible logic. Law must be equal to all.
state the advocate.
My lord.
Even then, I will talk with the.
And even after the DI is passing orders.
Happen, Mr. Badi, court will be imposing exemplary cost on the state. Nobody is.
Our law is settled. They should follow the.
If you have any confusion, Supreme Court you have not
unnecessary litigation.
Then Mr. Badi cases. Suppose you are the state, Union of India, files unnecessary cases. We have dismissed, giving a rider that this way you cannot proceed. Supreme Court also says.
Yes.
This will bring down the litigation. No, unnecessary litigations are.
And sorry state of affairs, is in spite of that, Shovik is not getting the higher scale till date. I'm communicating to you. Day before yesterday, he talked with me. And he is to, because DI is saying, no, we are giving, we are giving, we are giving. And he talked with me, file another litigation. Grateful. Much obliged.
Time for the appellate. That I am challenging the order dated, my lord, 3rd of September 2024. 2024 passed by the Honorable Single.
Who is your other side? You are
My lord, I am for the commission, my
who is for the state?
My lord, service is effective.
State and school is the answering respondent.
Acha. Transfer?
Transfer.
Oh, so affidavit of service you have filed.
Yes,
Who is
affidavit
the advocate?
Learned advocate, state, my lord.
School also you have filed.
No, but the school I have sent, but it has not delivered yet.
তাহলে আসো ওটা নিয়ে আসো
My lord, lordship, lordship.
17th
17th. Great. It is 17th. এই order গুলো কোথায়? At item number 11, I am for the petition.
I am for the state, my lord.
Commission is there.
My lord, that matter, my lord, extension of appointment of recommendation in respect of, my lord, validity of extension of validity of recommendation for period of beyond period of 90 days or within 150 days. That issue, my lord, is going on before your lordship, and your lordship passed this order.
ওই affidavit
Affidavit direction was given 20th November. It has fixed.
Lordship, this matter may be out of 150 days, my lord. Petitioner applied on after 150 days.
very good.
Sahib.
File an affidavit না we have if it's similar matter take that point in the
That matter, my lord, within 150 days, my lord, I believe.
No, I have applied school authority notice.
দেখো হিসাব করে দেখো I believe this is after
2nd April 2025.
154 days I calculated, my lord.
No.
I
Applicant
believe.
has
very good you file the opposition না
primary.
Our calculation is also after 150 days.
Lordship.
that one
This one, this one.
এটা এই matter?
কোনটা চলছি? এটা তো
Not beyond
সাহেব কারো-
60 days. Rule says, my lord.
No, সাহেব করো কবে হচ্ছে?
তুমি হিসাব করো।
Recommended upper primary level.
Mr.
11th of
Ghosh Chaudhary learned advocate appearing for the সেম ম্যাটার,
Similar.
তাহলে স্টেটের কেউ অ্যাপিয়ার করছে না। এই এই where is it? এটাতে ওটা কারেক্ট করে দেবে, ওইটা প্রথমে একটু লিখে দেবে এভিডেভিট অফ স্টেট কে সার্ভ করেছো, এভিডেভিট অফ
State
সার্ভিস কমা অ্যাজ ফাইল কমা
Full states of all
as no one appears on behalf of the as no one appears on behalf of the state respondents in spite of service comma we request we have given you time till that date.
Similar.
সেম কতগুলো আছে?
Last, this is last.
আরো আছে
13 also
13 সেম,
right 12.
if you make mistake in correction na
No, my
dismiss your
no, no, no.
Item number 13, my lord.
You are for the state. Oh,
তো আইটেম নাম্বার 13 এ ওনার নাম দিয়ে দিও,
13.
explain to him what we have passed and you name the vacancy also, file your opposition and we have said you have to indicate whether there is a vacancy, whether the vacancy to which he was recommended is still vacant or not.
20th November এর মধ্যে 20th November এর opposition
Next
20th November এর 27th মধ্যে রিপ্লাই সেকেন্ড ডিসেম্বর অ্যাপিয়ার করবে, তোমাকে শুধু ভ্যাকেন্সি পজিশনটা
14 কে আছো 14 no.
My lord, I am for the petition. I am led by the Mr. Samihul Bari. My lord, kindly make a short passover. He is appearing in another court, my lord.
Have you completed service?
Yes, my lord. I have completed the service.
What is the matter about
কারেক্ট করে দিচ্ছি আমি তোমাকে একটা
item number 14?
Yes, my lord.
You are for the respondent,
I'm for the state, my lord.
state school you served.
My lord, I have already served.
Where is your
My lord, I'm
evidence
for
of
the
service?
commission.
দেখি
Roster point মাথায় vacancy করার সময়
TMP ওটাই বলবো ওই অনুযায়ী
commission is appear.
as per roster point available কি এটা 14? হ্যাঁ স্যার 14 job loser want to
My
participate.
lord, I have hand service to the Mr. Dr. Shantanu Kumar Pattam. Okay, sir, already appeared.
বলে কত কথা বলতে
Where is Mr. Badi?
My lord, he is in another court, my lord. Kindly short passover, my lord.
Not this week. Yes, next.
My lord, this matter regarding this 90 days, 150 days, this recommendation extension. So, not in this case, my lord, your lordship, other matters are fixing on 28th November. So let it appear on 28th of November. My lord, there is one, I will make additional submission subject to what my learned friend submits. My case, and my lord, there is one order passed by the Honorable Single Bench that this issue has been discussed, which I would like to place before your lordship.
Rinky put that.
No, there is one similar matter came up, Shrestha Sen. Shrestha Sen's matter, Honorable Single Bench, that similar argument was made by the commission that after 90 days, it automatically gets lapsed. My submission was no, its life is up to 150 days because the statute itself gives its strength to live up to 150 days for consideration by the commission, subject to their discretion. Absolutely. But my case was that court has, my humble submission, that court has wrongly passed the impugned order saying that no, after 90 days, you cannot even claim for reconsideration of the recommendation, extension of the recommendation, even within 150 days. That is my challenge in this appeal. My humble submission is that 17.3, it says now even if 90 days, it dies its natural death. But the statute itself recognizes an resurrection and extension up to 150 days, within which I can make an application. Merely because I have crossed 90.
Then what happened? What did the court say?
Honorable Single Bench in my matter, this matter did not allow the same and it met with the same fate.
Now, in this matter,
this submission was made and the Honorable Single Bench allowed my petition and sent it before the commission for taking a decision.
Then what happened?
Then, my lord, after that, I am not in touch with my client. Possibly.
So you get hold of that decision. If commission has given, then automatically no question of using affidavit.
No, it has been. Commission has considered within 150 days. Commission has already considered.
Commission's ordered you wait. If the commission allows that, in that case, you are bound to succeed in this also. If court has observed and court has delegated it for the commission. The commission either will have to allow or if they reject, they will deal with that point.
My submission is this: I am not on the discretion of the commission. Commission may allow it, reject it. I am not on that. I am only to the extent of the
personal
scope given by the statute to me. That much. Not concerned with
when the division bench is in sitting, decision will be returned.
No, it was previously.
What you submitted or not, it's not the concern of the division bench. Division bench will consider the matter on its own merit.
On merit, yes. No, it is limited.
If you have any order, if you rely upon document, give copy to them and rely.
So at the next time of hearing, I will be placing this order. So kindly
first week of December.
Lordship, take it today itself. Then I
3rd December. 3rd December.
Very well. Let it appear.
Yes, next.
69. Sorry.
Give a copy of that order.
Yes.
No, that the other matter where you are saying court returned a finding.
Yes. I'm giving that.
Court said that within 150 days you can. Automatic cancellation of recommendation will not come.
No, the submission was made. Court allowed my petition, my prayer, and sent it to the commission.
The point dealt with.
Just a minute. I have possibly given the wrong order. ये कोथा है? मतलब kindly take this. Suppose it take.
No finding was
finding, yes.
Submission of the planet application of the commission was not accepted. That submission is
Extendable for 60 days more.
Kindly see
Upon satisfaction of the commission regarding availability of
submission was made in paragraph number 6. That was not accepted. My petition was allowed. I'm on that ground.
Allowed on what? Allowed and said what?
That it is to be considered.
If you are don't make confusing submissions. If your submission has been accepted, question of relegation to commission does not arise.
Here also I'm praying for relegation. I'm praying for relegation only. I'm not saying this to be decided here in this court because it is the decision.
Then we will dispose it of. Yes, yes, Dr. Patro, what is the problem? You consider? See this order?
আমি teacher. Anyway,
Kindly make it not this week, let me consider.
আরে কোনো কিছু নেই তো, ডিসিশন অন মেরিট পড়ে দেখো না।
Paragraph 6 না আপনার submission.
Whatever he is submitting in support. He says that my argument, commission's argument was rejected.
But the school there is vacancy. There are 93 students, one teacher. The school has also written to the authority that kindly, if he is sent to us, we will be relieved because there is only one teacher, 93 students. I have the documents to show.
My lord, kindly do not dispose it of today. Let me at least discuss with the chairman, make it not today, because in his representation, I will have thousands of
take instruction now whether your commission has decided this issue.
That I will have to take the specific instruction, but by looking at his application,
May 25.
by looking, yes, let me take the instruction, because by looking at the application which the petitioner made, the petitioner has written due to unavoidable circumstances. If that he has written, then I am sure it has been rejected.
Yes.
You have to explain that what was your reason.
So that is we are saying you consider, finish.
No,
My lord, I
if
have
it has been considered and rejected, then again, if the court directs, I have to do it twice. Besides that, citing division bench judgment,
then give a copy to him.
Hundreds of these cases I will
take instruction.
Happy if the matter is relegated to the commissioner.
My lord, I have.
Appellant is saying.
My lord, what happened previously, my lord, when the job loser.
All right, we will hear on that. Give a copy to him 2nd December করে দাও।
2nd December.
Yes, next.
My lord, I am for the.
না না ওটা নিয়ে নাও। Give one copy. ফেরত দিও। Yes, next 15.
16, my lord.
16.
My
Why
lord,
you are again here?
my lord, here the case is, my lord, School Service Commission pursuant to orders of the Honorable Supreme Court, my lord.
সত্যি তুলে দিলেই ভালো।
My lord, the School Service Commission pursuant to the order passed by the Honorable Supreme Court issued an advertisement for conducting teacher eligibility test and recruitment for special educated teachers, only special educated teachers, for TET as well as for recruitment. My lord, your lordship knows state is guided by guidelines of NCT, National Council for Teacher Education. It says that if a candidate is pursuing a training qualification, he is eligible to appear in TET. Commission did not allow that initially. My lord, writ petitions were filed before the last date of online application form. My application was also, my writ petition was also before the last date. A petition which was filed 2 days prior to me was taken up for hearing, and the court, after considering all submission, passed a order that no pursuing candidates are to be allowed to apply for TET. Single judge. And the last date was 24th. The Honorable Single Judge directed that on 25th, those petitioners should be given a chance for offline filling up. Last date was 24th. I filed my writ petition on 22nd. My lord, I mentioned, but it was, as your lordship knows, my lord, it will be taken up, order is passed. But my matter was taken up after reopening of the court. There the court said, my lord, the last date is over. Now you cannot get the benefit of this.
That is covered by Supreme Court. Get that Supreme Court said, must have said that date fixed by Supreme Court.
Supreme Court has said nothing.
I see. Where is the Supreme Court judgment?
Supreme Court judgment was passed in 2021. Thereafter, it was monitored.
Then why court said that you have come belatedly?
Court has said that since it was filed on 22nd, now the last date is over.
Last date of application?
Application was on 24th. I filed it on 22nd.
So now the process has started?
No, nothing has started.
22nd of December, 22nd of October?
No, I came on 22nd of September. Last date was 24th of September. In similar matter, court allowed offline application on 25th.
But today, how can it be held?
Because nothing has happened, my lord. It was only for online application form has been invited. Examination date has not even.
But that invitation date is now over, no?
Application date is over.
But I have filed the writ petition before the last date, firstly. Secondly, my lord, if the commission, settled law is pursuing candidates are to be allowed. Now, if the commission makes such mistake, my lord, the candidates cannot be made to suffer.
Now, what mistake commission made?
My lord,
Commission, you have your application, you could not have applied. According to the commission, is that you could not have applied.
Yes, but the rule says pursuing candidates are must be allowed.
Let us see. Let us then read.
Page 102, my lord.
Let us see.
102 page is the impugned order.
So the TET examination has not yet been conducted?
No. Then no date has been made.
এই হচ্ছে এক্সটেন্ড করা যায় benefit
It was 25th, it was allowed offline by the learned Singh.
So where is that order which has been referred to?
Yes,
You have that order? Page 105. In that it was allowed because the matter was taken up on 24th.
On 20th. But my matter was filed, it was already filed.
Then why offline court said?
Because it was on 24th, the court directed offline on that. And the order.
So you filed this appeal when?
My lord, appeal immediately.
28th October you filed.
Yes, the order of dismissal, my lord, kindly see when.
24th October.
Yes, and immediately with leave of this honorable court, I filed it. On Monday, my lord, probably I have filed.
Yeah. Yes,
Lawsuit may also consider. Page 108 also. Page 108 is the main order. Page 108 is the main order where where the honorable single judge decided.
You could have filed offline.
My lord, if I was not allowed directed, How could I, my lord? The advertisement was you have to apply offline, and those only who obtained in order from the court were allowed off.
You have delayed. Now they will be taking the point that it will lead to opening a floodgate.
My lord, even if, my lord, I know they will, this is the very point they also took before the single bench. Now, my lord, if the rule says that you have to do it in a certain way, they intentionally did not do it, suffering cost to the candidate. Now,
Why intentionally they did not?
Yes, my lord. Kindly come to page 95. Now, relevant page, this is the state guideline, my lord, and this is known to everybody. The commission is bound to follow the state guideline, my lord. Your lordship also knows.
No, we do not know.
My lord, your lordship has passed.
That is why you are that is why you are making submissions.
My lord, page 96 is the relevant portion.
Page 96.
My lord, eligibility for appearing in TET.
Yes.
The following persons shall be eligible for appearing in the TET. A person who has acquired the academic and professional qualifications specified in NCT notification. This is the first. Second, my lord, a person who is pursuing any of the teacher education courses recognized by NCT or the RCI as the case may be specified in NCT notification dated 23rd August. I am pursuing training qualification. DLED in special education. I am pursuing this qualification, so I am also eligible to appear in TET. But the commission has only given who have completed, not pursuing. And that has been decided by the single bench. No, you cannot do that. So it's a mistake.
Commission in the advertisement said that completed. Show us that advertisement.
Page 83.
Page
83.
Yes.
Page 83. I am placing in compliance with the direction passed by the Honorable Supreme Court of India on so and others, my lord, the West Bengal Central School Service Commission will hold the date 2025 for recruitment of special educated teachers in government aided or sponsored schools. These teachers shall have the duty to cater to the needs of students with special needs enrolled in upper primary, secondary, and higher secondary government aided sponsored schools in West Bengal, so far as the special needs are. Indicative number of vacancies are in terms of West Bengal School Service Commission recruitment of persons for appointment to the post of special education teacher rules 2024. The West Bengal Central School Service Commission shall take option from the candidates who already hold valid TET certificate, whether such candidates are willing to appear in the selection process on the basis of the earlier TET certificate or not. Candidates can apply only online on the Commission's website on and from so and the fees will be applicable. Now, my lord.
Then which portion is?
Yes, my lord. Now, this is the first advancement. Now, kindly come to page 85.
So, we shall take option means how?
My lord, in the online, that I do not know because I have not yet been able to register myself in the online, so I am not in a.
Why you are showing 83?
83 is the first advertisement that it is. They are giving that this is the online application form, time for filling up the online application form.
That's it. Very good. Then
Now,
page
85.
Yes.
It's a detailed notification of.
Show us the relevant portion. Eligibility.
Page 90.
Acha, you showed us page 96. What is the date of that guideline?
2011. Page 95 is the date, my lord, if you know.
2011. Very good.
2011. 11
Now, page
February.
96. Page 96.
Yes, 11 February 2011.
2011.
Yes. That is a under Right to Education Act, NCT being the academic authority, framed the guidelines in 2011. And
So
that is
then the earlier selection process, what happened?
no, earlier selection was everybody, it has to be followed. After 2010, my lord, your lordship knows, any recruitment for up to classes 1 to 8 are to be in terms of this NCT 11 February guideline and 2010 notification of NCT. Because NCT being the academic authority in terms of Right to Education Act, my lord, all state governments are bound by the NCT notification. And my lord, the learned single judge has considered these guidelines.
Let us come. Page 8, which para you, page 85 you were showing?
And on page 90 is the eligibility criteria.
90.
90.
Yes.
My lord, 14, your lordship has got that eligibility.
Eligibility, yes.
My lord, special education teacher classes 5 to 10 or 5 to 12. Minimum qualification for the post will be B.Ed in special education from RCI approved institutions and possessing a valid RCI CRN number. B.Ed with a recognized qualification. 6 months training of teacher in cross disability area inclusive education. Thank you. Nothing has been mentioned that pursuing students are allowed to participate in TET, and when I tried to apply, I was blocked because there was a column. What is your training qualification? There is no column. My application was not taken, and that is why I filed the report. And if your lordship kindly comes to page 1081. And this is the first writ petition which was decided by the Honorable Single Judge, taking into consideration everything on 24th of September.
They were within time.
We were also within time, my lord.
When did they file the application?
On 28th of September. I filed on 22nd of September.
You filed it on 22nd of September.
Within the time. It's just that the court, my lord, the business of the court did not permit the matter to be taken up.
Yes, what do you say?
Firstly, my learned friend is saying that the business of the court did not permit. Matters were taken out of turn on the last date, that was 24th. My learned friend also mentioned and moved other matters. Order is annexed here. But this matter, either he overlooked or he did not have the instruction from the client. So in spite of having filed it on the 22nd, he did not mention it on the 24th and he did not get it moved. Or the court was hearing, court heard it twice, first in the first half, again later on after we brought certain instructions. So that aspect that I was...
The only difference is that his petition was heard after the last date.
Yes.
This is the only...
Yes. Now coming to this angle, why did the court allow offline? Portal was still open when the order was being passed. The portal where they are to apply their online applications, that was open on the 24th till 5 p.m. in the evening. Matter was being heard, say, at 12 o'clock or 2 o'clock in court. So the court allowed offline because the candidates had made the prayer that they will not be able to come to the office within the day. So as a gesture that, okay, very well, you come by tomorrow morning at least, because we need to close the portal, or else applications will still be flowing in.
Portal was stopped. So portal time was not extended.
No, it was not. So on
So in
24th,
terms of court's order, you accepted offline. You did not
Yes.
prefer appeal against this.
no, it was a prayer of the petitioner that we cannot come.
No, my lord,
It was not on the merit. It was not on the merit.
was
The
not.
petitioner said that my client is in Malda, I believe, if I remember correctly. He cannot come by 5 p.m. today.
Whatever it was.
So the court said, okay, we accept it tomorrow by offline. That too within 1 p.m. It is only because they had moved within the time when the portal was open. That is why the court allowed. This petitioner did not.
His writ petition was filed prior to expiry of that date, but it was not heard by the court. Maybe he was not serious, or some other advocate was there.
No, my learned friend was there. Why he did
Learned
not
friend.
mention, I don't know, because he mentioned other matters. Identical matters. Kindly just see the previous.
My lord, I
order.
tell your lordship.
Kindly see page 102. Kindly see, he was there moving identical matter with his whole entire team.
No, you satisfy us. What is the problem now if you take offline?
Firstly, the date has
It is over.
logged back.
Now,
Now, if I
further process have been done. Any other date specified?
No, the schedule has not yet been published. That was my last instruction.
So
But that does not mean nothing has happened. Those thousands or lakhs of online applications which have been collected, those are to be processed. Those are being processed. So we are in a stage where we are preparing now to go to the next stage of the selection process. The cutoff date, the last date is given for a
Dr.
very specific.
Patro, you are a model commission. It is a fact. It is not that he did not file the petition prior to the closure date. In these intervening circumstances, would you not take because you yourself in respect of the regional level selection state repeatedly granted opportunity, any correction, because your mindset is to allow everybody.
My lord, in this particular matter,
we will not pass any order. You accept his offline. Finished. Nobody will come to know anything. We will not pass. As a gesture on your part, you do it.
I know that will be more dangerous for us as a statutory authority.
So why dangerous, Mr.
The question will come up that after closing, how all of a sudden one candidate after such a long time, because it is not, today the delay is not 1 day. Court passed an order in my favor, and yet I am being generous when thousands of other candidates are still, they will also expect the same generosity. Though they have.
No, they will not express because they did not file rich petition.
Let me make one suggestion. Let me make one suggestion.
A person cannot be totally unreasonable. এখন ওরা রিট পিটিশন করে তার এই অর্ডার
My lord, kindly let me give one suggestion. If we are to solve the problem, because the delay.
No, all right. We will incorporate that this order will not create any precedence for any application made, any writ petition filed subsequent to 24th. Finished.
Yes. So all I'm asking for is today, kindly make it not today. Let me talk to the chairman. Let me see whether the portal can be, what are the technical difficulties? Because the team which was controlling the portal. Let me try and get it done. That is what I'm praying for. Just not today.
We are reposing faith upon our officers.
Yes.
You are making it we are not standing in the way, Mr. Dr. Patro. Your argument, substratum of your argument will be every Tom, Dick and Harry will come and say, I have not, you have not yet. We will mention in our order that our order will not be treated as a precedent in respect of any writ petition filed subsequently to the closure of the date for submission of online. What more do you want? That at least will save you from future litigation.
I don't want anything more than that, but I just want to come back tomorrow with after discussing with the chairman, so that I can be absolutely sure that we will not fail.
Of yours.
তো ক্লায়েন্ট কোথায় আছে কাল ডাকলে আসতে পারবে তো
তুমি বললে আমি তাহলে আসতে বলবো।
না তাহলে কাল বলবো, পরশু দিন আসতে হবে।
ও আচ্ছা।
বাঁকুড়া
না, না,
ভোর
দিনে-
5টার ট্রেনে চলে আসবে।
আর সেটা তো আমাকে জানাতে
হ্যাঁ,
হবে।
মানে আগের দিন একদিন আগে জানাতে
একদিন আগে জানালেই আমি বলবো।
ঠিক আছে, আমি কথা বলে তোকে জানিয়ে দিচ্ছি।
ঠিক আছে।
তাহলে তুই ডাকতে পারবি। অফলাইনেও আমাকে পোর্টাল খুলতে হয়, আমি তো
হ্যাঁ,
অফলাইনে
ঠিক আছে। আমি আজকে রাতে জানালে চলে আসবো।
তো বল না কলকাতা একদিন কি হয়েছে?
Very advertisement itself creates some doubt. In that case, you will be facing much more difficulties.
It has been
That
taken
point,
by-
that point we have argued that why we did not allow those candidates. And they gave an undertaking for which the court rejected our argument, is that they will not participate in the recruitment process. They only want to sit in the TET which is being held. They will not participate in the recruitment
No, my
process.
lord, probably.
Not
No,
participate.
please.
No, I say no.
No, no, TET opens the gate for participation in
if I-
this session.
But
my lord, if
common rule, common advertisement.
this cannot
Rule
be.
provides that you are to have your qualifications if you are to participate in the recruitment part. You cannot read one rule and then not read the other.
My lord,
These orders do not confer any right upon
yes,
them to
certainly, if
participate.
I am
Take that
eligible to
point.
participate in the
That point
recruitment.
is taken,
at the
then
time of
everything has to be argued. Let us not go into that.
We will mention Dr.
They
Patro.
gave an sorry.
Dr. Patro, we will make we understand your problem. It is not that we are being unreasonable to you. We understand your problems also. You are a statutory body. Today, the arguments which you are advancing, these are not required to be advanced at all. If you say on the basis of that contention, you will appear. Or we will hear you and pass necessary order. Whichever.
Let me come back tomorrow. I'm sure.
I think you can
what
solve
fell
the
from
problem.
the yes, that is what I'm hoping. But let me come back.
We will mention, we will subject to hearing him. He can have no other say, because now if thousands of clients will come to Mr. Dasgupta, but Mr. Dasgupta will
Nobody
not.
has come and nobody will come.
We don't know. Future is uncertain, Mr. Dasgupta. Ashok heard Mr.
What service not complete, my lord?
2 weeks.
I'm for the board.
Applicability of the primary rules in case of inter-district transfer and this below 5 years transfer. So this matter will be covered by that matter. So kindly fixes it on 17th so that it will.
17th, how many matters we have kept?
One. Your Lordship,
One matter, there is an exchange of affidavit. That
everything
is
is
that
complete.
decided. Other matters will
The
be
matters will be decided. So kindly keep
Other matters also Lordship kept on 17th.
It will be on the 17th.
Grateful.
Grateful to Lord.
I appear
You are there.
of the writ petitioner's respondents.
Who is the appellant?
Not the now the section 5 application was there, affidavit in oppositions have been filed and reply also filed. The petitioner on behalf of the petitioner, Mr. Bikash Goswami appellant state. Mr. Bikash Goswami for the state.
Not this week. Appellant হচ্ছে not this week. No. Next.
Not this week.
Item 20.
20, my lord, I dictated for the district primary school council, Mr. Boyso, my lord, appearing, my lord, he will be, my lord, will be joining, my lord, very shortly. His health is not permitting. Yes,
Why what
slowly. He has been made to hospitalize last week.
So he is here.
Despite he has come today.
Can do the matter?
Yes. Coming, he is on in the elevator.
One very short point involved. Your Lordship has heard this
Which
matter.
for the state?
The petitioner, appellant.
State Mr. Boyso and he assisted by Mr. Manoj Bhuiya. Both will be come. Mr. Boyso, I have been informed he'll be come.
Yes, what is it?
Whether the issue is that whether this appellant,
the report of the board.
That report of the
report of the council is there.
The report of the council, it is there.
I have filed, my lord.
No, you are not for council. You are for council.
Yeah, he is for council.
Oh, the report দিয়েছে তো you haven't got the report.
Yes, ma'am.
Then
no time.
Then what is the problem? You want any exception required? No.
No, not.
So where is the order impugned?
The order impugned is at page.
He বলেছে 9 দিয়েছে।
Is at page 49. It starts from page 49.
49 of your stay application?
Stay.
अरे ये तो था मानस दा की
না না ওরা সার্টিফিকেট
সার্টিফিকেট পাঠাই আমরা লাস্ট পর্যন্ত কথা বলছি ওই আমরা তাই চেয়েছি মানে ফর্ম দিয়ে এইটা এই যে ফর্ম অ্যাপ্লিকেশন বিফোর দ্য ডিএম আচ্ছা আমি কোর্টকে বলে দিয়েছিলাম আস্তে আস্তে application of the chairman, family pension, যে ডিআই এর কাছে পাঠিয়েছিলাম তো এইটা দিয়ে তারপরে অ্যাটলিস্ট ডিসাইড করা যাবে। আমরা বলেছি আগে ডিএম এর থেকে লিগালে আনানো, আর আমরা ডিআই এর কাছে একটু লিখে টিখে পাঠিয়েছি যে কি করার জন্য ফর স্টেপস অ্যাজ পার রুল। নাও অনলি এই যে এইটা ডিএম এটা দিলেই আমরা একমাত্র প্রসিড করতে পারবো। মানুষ সাধুর কাছে পাঠাতে গেলে কিন্তু মনে হয় না তাপস এখনো ওটা পেয়েছে। বলছি সেই থেকে রিকোয়েস্ট এখন ও কি অ্যাপ্লাই করেছে সেগুলো দেখা।
So, criminal case is still pending.
No, my lord, the facts is that, my lord, this app, your lordship will find the name of the writ petitioner is Anjan Kumar Chandra.
Yes.
He has died. He has died, and my lord, during after preparing the appeal, so my lord, his wife, my lord, the widow,
No, what
she
is
has
the
been
status of that criminal?
one has been already dropped and another quashed, and another, my lord, because of the death of the but this is single accused, one accused is there, that was abated. That was abated.
When was that?
Well, it died on 31st of December 2024.
Pending একটা ডিসপোজড একটা ড্রপ আর
ওই কোয়াস্ট
পেন্ডিং একটা কোয়াস্ট
DCRB 81 is applicable.
DCRB rules, Lords.
Huh?
Yes.
Have you brought it?
DCRB rules is applicable.
My lord, that is applicable.
What is your stand?
Lords, my stand is a succession certificate, Lords. Who is the issue? The district magistrate issue a legal certificate.
That is applied for.
Legal certificate issue.
No, that is separate. Entitlement.
But entitlement without Lordship, here the criminal case is pending, Lordship.
What pending? Person has expired.
Yeah, but Lordship, when the Lordship drop it, then Lordship petitioner go there to court and directly the petitioner is died.
Why? Criminal case.
Then if the Lordship,
dying.
I knows Lordship, but as per your Lordship direction, then Lordship, I have no objection, Lordship. As per give the direction.
No, we are not saying you have. You
No, but
must
Lordship,
have.
here Lordship, district inspector direction is Lordship. I am Lordship binding.
Where is that district?
No, district inspector not say that. Here Lordship, the chairman of the district primary council filed a report before his Lordship. In paragraph, Lordship, kindly see the page 4, paragraph 6.
Yes.
Legal.
You filed one copy. Yes, Mr. Dev.
No, my lord, I believe subject to correction, 2 copies. If একটু দেখবেন না হলে একটা
Okay, what is the got it, Lordship? Paragraph, Lordship, page 4, paragraph 6, Lordship.
What is the stand of the district primary school council?
Chairman.
Our stand is that we have simply, my lord, that my lord, reported the incident that as per our request, we have received a notice intimation from the advocate that these are the matters been dropped and two are pending, and we have suggested the petitioner now and the appellant to obtain the legal aid certificate from the district magistrate, and also we have requested the district inspector of school to take steps, my lord, in accordance with the permissible and relevant rule. This is that because ultimately that DI is the pension sanctioning authority.
Have you taken any order from the learned court below?
One is your lordship.
Forever.
My lord, your lordship, your lordship will find at page 11 of their report. That the one your lordship kindly see page 11 of their report that has been quashed. One is quashed.
File for your case. Let's say as for my lord's submission lords, you go there to the would be.
Where is the order of the criminal code?
Well, one is your lordship will find at page 11 of their report that one is coerced.
And my lord, if subject
Yes,
to
ma'am. Your lordship
correction,
will find at page 11.
yes, that is
There
all
is
right. But
reference
last
to one
occasion,
case.
Yes, malad the another malad as because malad.
Why you are going for another? We are concerned with the case which is involved here.
No, malad they are referring two cases.
Single judge referred to one case. কি
Right.
বলছে আমি বুঝতে পারি না।
Oh,
No, malad from the report itself, malad it's appearing. I am not on the single judge report, but single malad yes.
I believe my lord,
That also that whether you have obtained this.
Have you got that legal year certificate from
Malad,
here?
that has been applied for.
my lord, that,
Applied, we know. Have you got it?
No.
my lord,
Yes,
please,
malad.
please,
Yes, malad. Legal year certificate, malad.
No,
not-
by the
not-
panchayat, not
But
by
this
the
has been
district
from the
magistrate.
panchayat.
my lord, in the last occasion, may I just
And also, my lord,
parts.
applied for before the district magistrate, collector, Bankura.
And on the last occasion, this was my lord the subject of discussion that he will be
Your lordship,
applying before the DM for the district magistrate for this. This much we are awaiting for. Last occasion, on the last date of hearing, this was the submission made before your lords.
Malad, may I submit, my lord, this widow is my lord, waiting. My lord, your lordship will dispose of this matter. Direction be given upon the petitioner in compliance of all the formalities.
yes. There are two accused person in this case. One, Bongsi Badon Pine and the writ petitioner. And Anjan Kumar writ
Yes,
petitioner. Kumar Chandra.
Yes.
Bongsi Badon filed a application under 482. That was allowed. The case was in that petition. The Anjan Kumar was not party.
Yes.
The case was allowed. That means the case was coerced. But in respect of Bongsi Badon. And lastly, coerced. And Anjan Kumar is hereby discharged from this case.
Yes, my lord. My lord is on page 11.
Yes.
Anjan Kumar discharged.
My lord, then my lord, that case is not referred as your lordship's. In the order, it's my lord, the order of the single judge.
Discharge from bail bond.
Discharge from bail.
Discharge from this case. That means are discharged from this case and
Discharge of
as the proceedings. Oh, total time. Both the accused person are such and such are hereby discharged from this case. So case has been quashed.
Yes, 5 or 20.
Have you got the order of the honorable this court quashing the criminal case?
This is not with me, but that case has not been referred by the single judge, as your lordship correctly held that the honorable single judge referred. Your lordship will find at page 49 that that case, the TR case number 143 of 2021.
As the proceeding
Page 49.
was by the year, both the accused person are discharged from this case and discharged from the respective bail bonds.
এটা একটা সেপারেট এটা সেপারেট জিআরসি উপরে দেখো
GR case হচ্ছে 77
page 49
And page 49 refers, my lord, the GR case number 143 of 2021.
এটা কি 49 of AGR case টা referred para to that is not this case.
143.
So what has happened in 143?
My lord, as because
Neither
of
you are taking steps,
as because
you are coming and telling us you are widow. What purpose will be served if we say subject to compliance?
that after
No, you will never get. You are his counsel.
my lord,
You have no interest in the matter. What we will do?
that
Do you understand the effect of this order? What will be there?
My lord, I got understand. My lord, these the
Subject to result, you give it, my lord. You ask him to pay. You come and file a contempt application, again, you relief should be given.
That only.
So is it not your duty that let me find out what has happened to 143? What is the last order passed in the GR case? Every day we are giving you time. Last time.
Your lordship kindly please.
Kindly,
After the,
my lord,
I am not on that.
people are, have you brought the point of law? Have you brought DCR scheme with you? See, neither you have the book, nor you have gone through it, that what will be the effect. Let me consider these judgments. And the judge says that I will not accept those judgments, I will not apply in those cases. Why? Sir, you must, when you do the matter, sir, don't leave it to anybody else. If we pass that order, that subject to compliance of necessary formalities, your DI will never proceed with the matter.
Subject to my lord's corrections, this writ petition filed by the erstwhile.
Then what great thing happened? You have got yourself substituted. Legal heir certificate, what is the, do you have any children?
Yes, my lord, that is there, my lord.
Then DM office he applied. Why the DM? You should tell us.
But because the last occasions, this was the rule that the DM has to.
See you here. Based on a complaint lodged on 3rd April 2021, one Khatra PS case number 12 of 21 was started. Another, based on a complaint on lodged on 24th February 2022, Khatra PS case number 5 of 2022. So 2 cases were started against the Onjon. Okay. One is in 2021, another is 2022. One document has been from the annexed with the report speaks that the Khatra PS case number 5, GR case number 77 has been quashed by this court. But what about the other case of 21?
Due to
you bring the document showing the status of these 2 cases. And one order is that of the ACGM that in view of the decision of the Honorable High Court, both accused persons are discharged in case of subsequent case. That is 2022, Khadra PS case number 5. But what about Khadra PS case number 12 of 21?
That 482 order I have found, but it is in respect to only Bongsi Bodon Pine. This, yes, CRR.
The order is to be looked into when any person can come. 3-4 accused person, one has come. That I don't know what the role played by the others. You quash my case.
That has been done.
Whether it was quashed in respect of a particular accused person or entire case was quashed.
It says, my lord, in such view, the impugned proceeding being GR 77 of 2022 arising out of Khatra such and such presently pending before the learned ACGM Khatra is hereby quashed.
Then
proceeding quashed. Entire proceeding quashed.
That is GR case number
77.
77 we are not saying. This is PS 5 of 2022.
Yes, 5.
5/77.
Yes, PS 5 of 2022.
143.
সেটাই তো জানতে, what had been 143
I need to take instruction. It has to be dropped because of death of this. But
matter was hard on
my lord, your lordship,
of
yes, my
September,
lord.
and you are
I beg your pardon, my lord. I have to, my lord, from my
you pass the order.
My lord, my lord.
And Mr. Boiso, what is your DM doing?
What lordship?
Where have you served this
When?
application for legal heir certificate?
When?
We will call your DM.
When you apply?
I have applied 29th of August 2020.
Was the receipt letter from DM office?
Very good.
Where is the receipt?
No receipt.
দাঁড়াও দেখছি।
You have applied for etai receipt.
Yes, 29th August, you have made a representation, they have enclosed in their report. They have enclosed, you have not enclosed. See, now where is the service of it? Show us that this letter was sub, we will call the DM.
Well, the acknowledgement is not
See,
there. For that.
if acknowledgement was not, was it not your duty to immediately go to the DM office, make a communication?
Then
this period of email service and everything available.
ওর কাছে আসে এরা কিছুই করে না। মানুষগুলোর কাছে শুধু শুধু You got the certified copy of the, you bring the certified copy of the trial court in respect of both. Then what is the data? Everyone.
That day you find out what had been the fate of the other GR case, 143.
143,
which is referred to in the order impugned.
Paragraph.
You as our
in our report, so for our information,
just 143. Click it in the whether in connection with 143 in the criminal revision file. You make it that
trying.
You will find it out.
I shall
and the
make it.
criminal revision file, get the date of the order and bring out the order from the website and help them. A widow is crying for these benefits.
That much.
No, but
Mr.
so far,
Bosso,
that is
we
the
are just
instruction that
discussing
has not
about
been
that.
filed. No revisional application has not been filed. So far as 143 is concerned.
No, has he spoken with her client, with his client? See how you have conducted.
No, she is not filed.
My lord.
From internet GR 143, it will be.
I shall be trying to search out if
In such
anything.
a way, you
Now,
find
now.
the GR 77.
76. And Mr. Mishra, you give a ring to this your district magistrate.
But here, Lord, see, here is the receipt copy, Lord,
Forget now. That application has been made.
Lord, see, here, Lord, see, election duty is there, no video, no DM, no available. If the Lord, see, I have received the certificate, receipt copy, then I am direction by the DM. This is the
For
receipt.
this,
Certificate copy, sir,
DM is not a major part. Then, Lord, see, I am Lord, as per your.
No, the question of
uploaded copy গুলো নিয়ে
Lord, see, I am trying to my.
না, দেয়নি।
এফিডেভিট করে বলেছে
এটা তো পঞ্চায়েত। কার সার্টিফিকেট কোথায় দেখছো দেখ?
না না এটা ওর এফিডেভিট করে নিজেই বলেছে।
Lord, see, I am trying to my best level of the Lord, see, best. Trying to take. Give me Lord to supply the copy.
What way the matters are being conducted, we do not understand.
Only supply the copy, Lord, see, where the district magistrate, where they submitted the district magistrate application.
You submit a copy of the application seeking legal air certificate from the DI to Mr. Boisso. Copy of the application so that he can communicate with the
Lord, don't worry, Lord, I am.
In that event, the another application which has already been submitted before the DM, and another application has to be made before the DI.
DM application, you did not understand what my brother has said.
Sorry, my lord.
Have you applied before the DM?
Mine.
Seeking legal air certificate?
Mine.
Have you got the copy?
But the copy
application, you have nothing.
But a copy with me, that is not acknowledged. But that's the issue. I cannot.
So what was your junior doing? From
I asked him to bring the copy. He told that there is a copy. So why this copy?
Yes.
This ought to have been.
There should be an acknowledgement. In DM office is very well.
He's your chamber junior. He's your chamber junior.
No.
Sir, you are young people. You are practicing in High Court. First, you are our officer. You are fighting the case of a widow. before the matter is taken up, you should go to your senior's chamber, discuss the matter, what matter is meeting, which column is it. This was the practice. If you don't learn these things, how will you continue? No, no, your apology doesn't do, because this is an advice which we are giving.
I communicate, Lordship, but due to her financial hardship, she is unable to.
Financial hardship will be removed only after she gets the money. No?
Traveling, Lordship. That is the difficulty.
When you saw the brief, was it not your duty that where is the acknowledgement letter?
I asked her, but
Not when will you come? When will you come? Tell us.
Well, today is Monday, next week, Monday.
You need certificate copy.
Mine. No, my lord, that the
Certificate
this
pre-order.
dropping of the
Last order of 2 criminal cases
my
and criminal division. 482. 482 you will get uploaded.
That is available.
That is available. My lord,
We are not so technical.
but I will. My lord, I will. But this is my responsibility, my lord. I will produce all these two things. One is the my lord.
Give me lordship 2 weeks time, lordship. In the meantime, I try to my best to
Yes.
the lordship certificate, legal year certificate.
And give a copy of the application to Mr. Boyso, you will get the.
Lordship, I am giving you, lordship. I will.
That GR case 1 I just about to read, but 145 and 40
Very good. Find it
are
out.
available.
We will keep it next. আজকে কি বার? সোমবার তো? Next Wednesday রেখে দাও।
Sir, not Wednesday also. I am go to the Chennai or check up lordship. Here lordship of doctor advisor, angiography. I lordship.
Then Tuesday we are keeping.
But it's 2 weeks time.
143 টা নেটে কিছু আপডেট
2 weeks time, lordship.
যা 143 টাই কিছু
In the meantime, I try to lordship.
25th November.
Give me some password.
Submission.
Item number 21, I am appearing for the West Bengal Joint Entrance Examination Board, my lord.
But I am the petitioner. I am from the petitioner. Kindly not today because my senior is absent.
My lord, senior is absent. My lord, instead of not today, my lord, kindly keep it on Thursday or Friday because nothing, no document has been annexed, my lord. My lord, I will try my level best to bring the documents from the board, my lord. Nothing is there, my lord. Only memorandum of appeal and section 5 application. No stay, no document is there. For proper adjudication, documents are required, please.
Next Thursday.
So next Thursday, and you ask your senior to serve a complete application to Mr. Chaudhary. Okay?
This Thursday, my lord. This Thursday.
Thursday.
Fine.
You serve.
Thursday week.
Thursday week.
No, my lord, Thursday. This Thursday.
Will he be available on Thursday or you will again pray for
No,
that?
available.
Who is your senior?
Advocate Sarvesh Pal.
Uh-huh.
Sarvesh Pal. Advocate Sarvesh Pal.
You serve the notice come next Tuesday. Next Tuesday. Yes.
Next Tuesday, my lord. Tuesday week, my lord. My lord, this Friday, my lord, kindly, my lord. I will
Yes, next Wednesday. Yes, next.
My lord. In this matter, my lord, I am led by Mr. Sarwar Jahan, my lord. In this matter, my lord, I am praying only my lord, 10 days extension for filing my lord reply, my lord.
File it will go out of list.
My lord.
Pension and get it listed.
Can you take
Ashok,
it up?
the learned advocate appearing for the
Number 23. 23, I am appearing for the appellant. The appellant is not willing to proceed in the matter.
The learned advocate, Mr. Das, learned advocate appearing for the appellant. এটা কি আগে অর্ডার ছিল?
তো বলছো
এই প্রথম অ্যাপিয়ার করছে। ডিসমিসও তো করতে হবে, রেজলিউশন নিয়ে বসে আছে।
ওই চ্যাটার্জি বলতে পারে তো অরিন্দম চ্যাটার্জি। চ্যাটার্জি ও তো
চট্টগ্রাম কে করেছিল? ঠিক আছে তো চিঠিটা পাঠিয়ে সুব্রতকে ডাকো, সুব্রতকে ডাকো। থার্সডে উইক করে দিই, হ্যাঁ থার্সডে উইক করে দাও।
My lord, I am for the petitioner, I am praying for not this week.
2 weeks করে দাও। এও কি প্রথম? এগুলো কোত্থেকে এনেছে? ওই হরিশদার ওখান থেকে?
Lordship, in this matter, Mr. Shobhashachi Mondal is appearing for the petitioner Lordship. Suddenly he met with a road accident. He is on bed rest, Lordship. Kindly keep it after 2 weeks, Lordship.
Second December?
Grateful.
Yes. থার্সডে উইক কোন দিন তোমার কম থাকবে দেখে দিয়ে দেবে। Next.
29. For the petition.
What are you saying?
My lord, I am praying for now for the petition.
কেন? Why?
My lord, I am led by Mr. Shweta Dasgupta. He is engaged in court number 70.
Thursday week? Yes. What has happened? Again resolution or what? কি বলবে ওরা?
I am for Lord, I am for the appellant led by Mr. Gaji Mailani Senior, Lord, in this matter, Lord. Lord,
You'll do it?
my lord.
So,
allow করিস কি?
হ্যাঁ
Lord, the instant appeal has been filed before this honorable court, my lord. Praying increment for
supplementary evidence given?
my lord. There was some delay, my lord, in the last occasion when the matter was moved before your lordships. Your lordships were pleased to condone that delay, my lord.
আপনাকে লিখে দাও না, এই যে ঘোষ করতে অ্যাপিলেন্ট লিখে দাও না একটু আপনার, এই যে ঘোষ করতে একই
H Ghosh.
H Ghosh, Himanshu Ghosh.
Oh.
H.
এই পড়াটা পড়ছি না না PAUL. Oh. Holy. দিদি নতুন কি ডিসিশন তোমরা নিয়ে নিয়েছো?
না আমরা কি করে নেব?
লাস্ট যে অর্ডারটা ছিল তোমার একটু ডিরেকশন
বুঝলাম, ও তো এটাকেই চ্যালেঞ্জ করেছে, আবার নতুন কি ডিসিশন?
নিয়ে নিলে বলতে ইনফ্যাকশন হয়ে যাবে।
Again send back. Again send back for
By the Supreme Court.
Huh?
Again sent back by the
Yes, my lord.
trial court.
Kindly come to page number 48, my lord, the Honorable Supreme Court's order.
Page 40.
Then why you are agreed by this?
My lord, in accordance with the Honorable,
Who are you? Who are you?
I'm the school.
Vishwanath Ghosh.
Vishwanath Ghosh.
He is the
No, it's petitioner. Vishwanath Ghosh.
You are the writ petitioner.
Writ petitioner.
Who is he? He's writ petitioner, school secretary.
No, my lord.
Then what did the writ petition was filed for?
Petitioner is represented as secretary of the said school.
সেটাই তো বলছি। তাহলে now you challenge, writ court has passed an order directing the board ke respond number 3 who is free?
Board
to take a decision. Why you are agreed by it?
Lord, kindly come to page number 48 once again, Lord.
48.
48.
My lord, moot question before.
Yes.
Lord, heard Mr. Rauf Rahim, learned the counsel for the petitioners and the Ranjan Mukherjee, such and such, and the singular grievance that has been urged in this special leave petition is that division bench of Honorable High Court should have been well advised to decide the justification for grant of recognition or for establishment of a school to meet the parameters, but it left it to the authorities to decide.
Very good. After this, you made a representation to the board.
No, fresh application was the order. That has not been made, madam.
As
you filed an application in terms of this order. Now what happened?
So it has not yet been decided, my lord.
No.
So you came to the writ court.
My lord.
It was not decided, so you came to the writ court.
My lord.
Now writ court has passed the order
that
respondent number 3 shall consider.
Consider.
Then why you are aggrieved by this order?
My lord, after the order of the Honorable Supreme Court, my lord, an application has been made by the petitioner. That has not been considered.
he approached to the Honorable Court. Honorable Court directed the board to decide that issue. That issue, 62 is an impugned order, challenged by the petitioner before the single bench.
No.
Page 62 is the order.
That is the impugned order passed by the board.
This is under challenge in the writ petition.
It is under challenge before the
writ court.
So very good. Now what the writ court has said?
Let kindly come to page number 72 onwards.
Here, tell us. What is the direction?
Page number 80, my lord, in view of the foregoing discussions and reasons, this court is of the considered view that the findings of the reasoned order dated October 4, 2028, passed by the respondent number 3, are just and proper. We are agreed by this. The reason.
Where is the page 42 order?
Reasoned order.
Page 62.
Page
62.
So by that order, the petitioner was directed to file a recognition application in format.
In format. The moot question is that.
Then what happened? You challenged it. My lord. Now read with that paragraph. However, read.
However, following the direction of the Honorable Supreme Court, the petitioner shall be at liberty to apply according to the provisions under the prevalent law before the respondent number 3, seeking recognition of the relevant school, strictly in accordance with law. In the event such an application is submitted by the petitioner and or the relevant school upon compliance of all the necessary formalities in law, then the respondent number 3 shall consider the same after affording an opportunity of hearing to the petitioner and shall pass its reasoned order strictly in accordance with law on the issue following the said direction of the Honorable Supreme Court.
Very good. Then why you are agreed by this order?
Lord, I am agreed because the paragraph number 19 of the Honorable Single Bench order on paragraph number 19, page number 80, the Honorable Writ Court held that the findings of the reasoned order dated October 4, 2018, passed by the respondent number 3 are just and proper.
So what was the finding? Page 63, what is the finding?
What was the finding, Lord? This is page number 62. The
page 63
finding.
Last paragraph, findings. Last paragraph.
The ad hoc committee of the board took note of the fact that an inquiry report dated 27/8/2028, memo number such and such of DI of schools, Nodia, was submitted at the time of hearing. The school authority did not submit any fresh application to the board under the prevalent law. In accordance with the verdict of the Honorable Supreme Court dated 28 April 2017 as per bylaws 2007. Hence, the ad hoc committee is not in a position
as per where you are reading?
Page number 63 of my stay application. Last paragraphs, word findings underlined. The ad hoc committee of the board took note of the fact that an inquiry report dated 27/8/2028, memo number such and such of the DIs of the schools, Nodia, submitted at the time of hearing. The school authority did not submit any fresh application to the board under the prevalent law. In accordance with the verdict of the Supreme Court dated 28 April 2017, as per bylaws of 2007.
What are these bylaws? What are these bylaws?
Bylaws means schools bylaws. Look, there is a conflict.
The school, my moot question of my learned friend, if I understand correctly,
it was not made in consonance with the prevalent.
My lord, what happened, my lord, he approached to the Honorable Supreme Court. Supreme Court directed to apply after applying the prevalent rule. The case in the meantime, my lord, control and expenditure has came to force. And after the control and expenditure act, new recognition means without any financial assistance. If it had been the case of the petitioner, I have understood correctly. If it is made prior to prevailing rules, the case of the petitioner, if it is prevailing rule, that I should have considered before control and expenditure. এটাই
Well,
এটাই argument.
this school was never
Please,
recognized.
please wait. Sir.
Kindly consider the page 73 of the judgment, my lord, facts.
Yes, what is your content, sir?
My lord, the school was never recognized. My lord, the petitioner, the school was established sometime in 1986. Thereafter, they applied for recognition in that time. Board rejected.
When?
In 1998, board rejected the prayer for recognition of the school. Thereafter, Lordship, in 2007, a writ petition was filed by the school authority, where, my lord, the direction was upon the DI to hold an inquiry, DLIT to be held, then forwarded to that time it was a commissioner, not commissioner, director of school education, and thereafter upon the report to the board. So, my lord, this order was in that DLIT, my lord, the recognition was not recommended for by the DLIT team. Therefore, my lord, challenging this order, my lord, division, order of appeal was preferred by order dated 12th February 2009. Your lordship, a division bench set aside the single bench order, directed the school to apply afresh as per bylaws 2007.
Where is that order?
That order is under challenge in the writ petition.
No,
Yes.
No, তার আগের division bench এর order. Later against the Supreme Court here.
Yes, well,
Is
there,
the order against which
that order has not been annexed, but it has been stated in the paragraphs, your lordship.
Yes, no, page 49, what is the Supreme Court order?
Yes, well, I am giving the chronology what happened. Thereafter, your lordship, this petitioner preferred a review application of that order. Well,
where is that appeal court order? Review, appeal.
Not annexed.
No, not annexed. Nothing has been annexed, your lordship. Difficulty is that, well, I am just giving the chronology what happened, my lord. 2009.
Chronology, what will you please read page 49 first.
Page 20 of the supplementary affidavit. The review order is annexed.
Page 20.
Page 20 of the supplementary affidavit.
Yeah, okay, supplementary there anything?
You have given copy to her.
My lord. Page 20. Division bench order is page 10 and
First writ petition is page 18, page 5.
Page 5.
That is of 2007. Ki bole?
Yes.
Initial original application for recognition was in 86, you said.
86, rejected by board in 1998. Thereafter, writ petition filed in 2007.
Now, what did the writ court say?
Now, writ court directed.
Yeah, just now. To send the DLIT, etc., etc., then consider. Very good.
Thereafter, my lord, this order was challenged by the school.
In
page 10.
Supplement এটা? In the Justice Banerjee said, rejected the writ petition to be treated as a representation.
Gotcha.
কোথায় বলেছে?
একদম লাস্টে সাপ্লিমেন্টারি আগের দিন আপনি চলে যাবেন
সাপ্লিমেন্টারি এফিডেভিটটা দিয়েছিল কি ইয়ের জন্য অর্ডার গুলো এনেছে
কি আমি বুঝতে পারছি না কি যে করেছে না।
আচ্ছা সাপ্লিমেন্টারি লিস্টে আছে ওই জাস্টিস ইন দ্য ম্যাজির অর্ডার
Have you made a list of dates?
My lord, formal list of dates has been placed in my thought list of date in my MAT.
ওই বাবা তাও তো গেলাম না
Lord, may I submit, my lord?
আরে কি সাবমিট করবেন? You are not being able to explain. We are asking you.
My lord, kindly come to, my lord, my
You
soul.
tell us what is your story. You tell us now what is your
My
story.
lord, kindly come to paragraph number 36. That is my story, my lord, at all. Paragraph number, page number 14, paragraph number 36. This is only my contention, my lord. The learned single judge, while disposing of the said writ petition, being WP number such and such, without considering and appreciating and determining the salient characteristic of prevalent law and bylaws. The application dated 2/6/2017, preferred by the present appellant exclusively in accordance with the solemn order dated 28 April 2017, passed by the Honorable Apex Court in special leave to appeal number such and such, was rejected by the board concerned by impugned order dated 4th October 2018, and such gross anomalies have not yet been prudentially dealt with.
So what was the date? Kindly come to page 49. What did the Supreme Court say? Supreme Court said that you have filed a fresh application within 6 weeks.
6 weeks.
Hence, with all requisite papers under the prevalent
law.
Under the prevalent law. So what was the prevalent law according to you? Did you state in the application that this is the law in which you have to
Prevalent law at that point of time, which was relevant?
No.
At that point of time, which
When,
point?
when I made the application before the board,
The DI inspection was held on 27th August 2018. That is after coming into effect of the School Service Commission Act. ঠিক মতন বলে। কেউ কিছু লাগছে, ও কিছু লাগছে, আর এরা ঘুরে বেড়াচ্ছে না। এখন বলছে অ্যাপ্লিকেশন করো ফর প্রিভিলেন্ট, which is the prevalent law
by rules 2007 where
show us your bylaws. Why 2007 bylaws, madam?
Prior to
here on the Supreme Court order.
Yes.
Huh?
Supreme Court said
fresh application within 6 weeks under the prevalent law.
Now
so when was the Supreme Court order passed?
My lord,
Supreme Court order was passed
2017. So at that point of time in 2017, what was the law which is prevalent under the land?
No.
So my lord, 2017 to 2007 bylaws.
When cause of action arose?
No, under the prevalent law, your lordship.
When cause of action arose?
Where from did you get this bylaw of 2000?
Well, that is in
this is your order. This is board's order.
That is
where from your ad hoc committee found this 2007 bylaw?
That is in the school code, your lordship, under which an application is to be made for recognition of the school
code. Have you brought it?
School code আছে তো।
Not today, my lord. Aja.
এসবগুলো ইয়ে করা সিলেকশন
মানে
আর কি বলে
right, school was established in 1986.
Yes.
When he applied, my lord, that is not clear. But school board rejected the prayer.
So what you rejected? What his application?
Yes.
1998.
1998.
Yes.
Why, my lord?
So
Board
he
cannot reject on its own. Board.
Page 50. The board is rejected 50.
1998.
No, my lord, that is page 2017. My lord, pursuant to the order of the Honorable Supreme Court. Page 50.
No, initially
Oh,
it rejected.
that is school was established in 1986. Thereafter, they made an application.
My lord.
Board says that it was rejected in 1998.
No, I don't see. I find from the writ petition
Oh, okay.
itself.
Now they filed, there was a delay. They filed a writ petition in 2007, most probably challenging the rejection order.
My lord.
2007. Otherwise, they cannot any cause of action. Either they will file a fresh application challenging inaction, they will file a petition, or they will come challenging your order passed in 1998.
Lordship, but this it's better, Lordship, they bring up with the application, then we can understand. What was the challenge?
Acha, where from did the single judge come to page 79? Last paragraph 16, last 4 lines. Acha, let us read from, wait, we are reading. Page 70, got it?
Paragraph 16.
16 portion made by the next page you turn, Supreme Court.
Yes.
It appears that the court was permitted to fresh application within a stipulated time frame with requisite press under the plenary. The order of the Supreme Court was a fresh order. Order was passed by Supreme Court on 28th April 2000. On reading the said order and direction of Honorable Chief, this court also the view that when a fresh application was directed to be submitted with a direction to consider on the basis of the prevalent law, in terms of the fresh order, the prevalent law has to be considered and understood as the law prevailing as on the date of such an application, submission of such an application by the petitioner. Application is submitted pursuant to the order of the Supreme Court. There is no dispute. But you will consider it from the date when the application was filed or from the original date when they applied, when you rejected.
No, from the date when they filed the application.
When? Tell us.
Well, that they have not filed a fresh application. That is the
fresh application has to be after the Supreme Court order.
Page 50.
Then Supreme Court order said file the application. Consider it as per the prevalent law. So what will be the prevalent law? Prevalent law will be the application which was rejected by you in way back in 1998. So you have to
Well, may I?
No,
1998, there was a conception of organizing.
Show us 98. Please show us 98, 1998 order which you passed.
Well, that has not been annexed. That all statement, my lord, that is the difficulty. Nothing has been annexed. And the supplementary affidavit also.
Wait, sir.
Lord, if your lordship kindly come page 12 of the division supplementary
Division bench order.
division bench order.
Division bench order.
Yes, what do you want to?
My lord, since my lord, kindly page 12, since the observation of the division.
এই যে দেখো
কত কথা না 12
to consider the prayer for recognition of this petitioner will file a praying for it. This is a fresh application to be filed for against this review was preferred.
Against the review was.
Then what was the review order?
My lord, then next page. My lord, page.
So from Mr. Das, page 12 is you have to file a fresh representation.
Page 20.
Consideration will be from the date when it.
Page 20. 20.
Establishment. 86 establishment.
My lord, kindly see page 20. 20. Or supplementary affidavit. এগুলো আপনার বলার কথা.
Yes,
this is a review application and this is the order of the review.
That's satisfies. What?
Page 24.
No. Well, the question of application, which rule will be applying, my lord, that is in the division bench order.
Sure.
Yes, page 12, will lordship kindly take.
We have seen page 12.
My lord, the last paragraph, my lord, may I read of page 12? The learned advocate of the appellant draws our attention to the newly introduced provision being West Bengal Board of Secondary Education Recognition Bylaws 2007. We further direct that such application is to be submitted by the writ petitioner appellant within a period of 2 weeks before the West Bengal Board of Secondary Education, and the concerned authority will consider and dispose of the same within a period of 6 weeks from the date of receipt of such application, keeping in view the provision of bylaws 3, 4, 5 of the aforesaid bylaws.
This has been struck down by the Supreme Court.
No.
Yes. Yes. SLP was preferred.
Yes, but it was not been struck down, Your Lordship.
It has been substituted by fresh paragraph. What is the fresh paragraph read? Achha, first
Number 49.
Wait, sir. Review what was said. Attempt for.
They preferred review of the division bench.
Page 24, page 23, last paragraph. The cost. At the cost of repetition, you observe the impugned judgment in connection with the review of sitting aside in review within a will consider the claim of the applicant recognition under the provision of attention of the consequent view of the applicant. In spite of our repeated consequences, we have also failed to draw our attention towards the material on record. The action of the instrument challenging is the prayer of consequence of recognition of institution. Therefore, no pleading of applicant is necessary to mention that. Therefore, taking attempt to make out a case of review was rejected.
So it was dismissed initially. Appeal court said it has to be in the appeal court order which you showed us, page 13.
Yes.
In terms of the bylaw of 2007, that was taken up in appeal. No, the appeal court said in terms of 2000, that was challenged in review. Review court said that we cannot change.
Yes.
Then Supreme Court.
Now Supreme Court order, in that Supreme Court order, both the writ petition order, appeal court order, review court order merges. Then
that is also indicated, my lord, in the cost title.
Cost title of?
My lord, page 48.
Supreme Court order.
Supreme Court order. Page 48.
Yes.
Arising out of, my lord, second. At the top.
Singular.
At the top.
Yes.
Arising out of the impugned judgment order, then such and such in review, in FMA passed by the both the order merge.
Page 40?
48. At the top.
Right. Now, what is the Supreme Court order? Page 49, second portion. So, where is 2007 bylaw here state that you consider it in terms of bylaw?
Well, relevant rules means
as we are passing, a board will not be influenced by any observation made by the single judge or division. Be clear, we have not expressed our. So you have to fall back on the provisions which were existing at the time of the initial application was made.
My lord, if it is so, my lord, then next page, pursuant to the order of the Supreme Court, they have applied afresh.
Yes, court said you apply afresh, but it will be considered in terms of the prevailing law. Court did not say that no further application is
prevailing rules means date of the applications of the rule.
Yes.
Our interpretation.
Where is sir? Thereafter, board shall consider with it. Board shall have where you are stating?
My lord.
Well, as the recognition has not been granted and the petitioner feel aggrieved, we permit the petitioners to file a fresh application within 6 weeks hence with all the requisite papers under the prevalent law. Well, what is the prevalent law? As per my understanding is the law which is prevalent on the day and on the order which was under challenge. The single bench, the division bench and the review petition on that particular day, the law which was in force.
Jaji, try to understand one thing. This order does not come in vacuum. It is not that first time Supreme Court was approached. Supreme Court was considering a litigation which was way back prior to the commission, this 2007 regulation. This direction does not come from a vacuum. Fresh application has to be made because board has no records. So fresh application has to be made. DLIT inspection was in terms of court's order. That has to be considered, and on that basis you have to consider in terms of the rules which were prevalent on the date of the initial application.
Your Lordship, board does not grant recognition, cannot grant without the recommendation from the school education department. Well, the system is, even if an application reaches board, my lord,
Required, you
the
pass.
ST will be held, board can
We do not know what order ultimately will be passed. We are considering the manner in which it has been. Board has refused it, proceeding on the basis that as Supreme Court said, fresh application, it will be on the date of the application will be after control of expenditure act. 2007 provisions have also come into effect. So no recognition, no aided recognition can be granted.
no it is not yet recognized at all. No recognition has been granted. Aided or unaided, no, it is not at all recognized.
So you speak, why does your ad hoc committee apply to afraid to return the findings?
No,
What is the findings?
Direction was upon the board to consider. Thereafter, board gave a hearing and considered, because
saying that I
not
will
recognized.
You said that I will not consider because this is as per the prevailing law. কি বলেছে ওই order?
Even my lord, even today, as per the 2007,
if you unnecessarily quarrel with the court, no purpose will be served. We are asking a legal point. Why your board has not? Don't be a technical officer, Ms. Bhattacharya. You're a senior counsel in this court. Don't be like the administrative authority. Here, this is the point. This is the point. Have a larger thought on the issue. You are so vague. The argument which you are making, Ms. Bhattacharya, had it been incorporated, we could have understood. You are trying to support this order on the basis of the line which has been given. The findings, he has not said a single word that your application is not in consonance with the Supreme Court order, because the Supreme Court order says it will be on the date of the application which you have filed after. কোথায় দিয়েছে বলো? Not a single line. He also doesn't know. Everybody is passing off his buck. Oh, you didn't get into. High Court said go and consider. Supreme Court said make fresh application. And person is. আর পাবেও না।
No, after the new rule, পুরনো practical হবে। করা যাবে, ওদের
সেটা কি মিটে দিবে?
Then also, your lordship,
সেটা সাইড করে।
আচ্ছা, সিঙ্গেল বেঞ্চ এটাকে রিভাইভ করে বলে দিল 2007 সিঙ্গেল বেঞ্চ দেখুন যেটা চ্যালেঞ্জ করছে।
হ্যাঁ, সেটা তো বলে দিল 2017 79 কোথা থেকেও পেলো এটা? যেহেতু বলেছে ফ্রেশ অ্যাপ্লিকেশন করতে হবে, প্রিভেলেন্ট ল হ্যাজ টু বি কনসিডার্ড এন্ড আন্ডারস্টুড অ্যাজ দি ল প্রিভেলিং অন দি ডেট when the application was made.
1966 shall not be construed and understood as equivalent law. Equivalent law.
যদি তাই হয়,
ও বলে দিল আগের রিপিট।
Then, your lordship, even if my lord, he has been directed by the Supreme Court also to file a fresh application, whether that fresh application filed by him.
Page 50.
2nd June 2017.
Page 50.
I mean, this is not an application. It must be made in a proper format. This is not an application.
Again, you are talking like an administrative officer.
But your lordship, application.
Your secretary will say this.
Well, my lord,
don't be the secretary. Be the lawyer of this.
Lordship, my lord, suppose there is a change of name or change of date of birth.
You should have called the secretary and told him that what did you understand there in your head? See, these officers, they let us do something, let us do, we will shun out the claim. This is their mindset. They never think in their mindset. I am government employee, I will not write any order in which will turn back upon my shoulder and my salary will be stopped. Unfortunate mindset of our administrative officers. And person is languishing, High Court Division Bench reviews Supreme Court from 1986. Is there any existence of the school?
Yes, my lord.
Bring the documents. The students are there, registers are there. Bring those
My
documents.
lord, I will certainly lost my.
This direction which has been passed will take again 20 years. By the time myself will go, he will also go, school will also. সেই জন্য you must be cautious.
Why are you so eager to go?
20 years.
Because defending the administrative officers.
20 years.
They are saying like a good system. Your officials are proceeding as if he doesn't know anything. Apply your mind, sir.
Actually, here prevalent law is to be interpreted. Whether prevalent law will be 2007
Or prior
or
to that.
1986 law. That would be.
Thank you.
Now, if we arrange the facts, and then 1986 the school was established. Thereafter they made application seeking recognition. You rejected it in 1998.
We rejected because the education department did not recommend us. Board only grants recognition.
Where is that
but
order?
Before that,
that is not annexed.
before that they came
The system, Your Lordship.
alleging your inaction. Alleging your inaction.
What happens, Your
Then
Lordship,
as in
even in
compliance,
old rules,
then in compliance with that order, you rejected his prayer in 1998. Then challenging your order passed in 1998, in 2005 he filed a writ petition. Then the said writ petition was disposed of, directing
fresh DLIT.
And specific time frame was given. Within such and such is to be done.
They challenged it.
They challenged it. Division bench says that you file a fresh application as per bylaws 2007. They file a review application. Review court, or no, we shall not interfere. They went to the Supreme Court. Supreme Court says, yes, taking note of the all facts, says you file a fresh application under prevalent law. Now the question comes,
what is the
interpretation, what will be the meaning of the prevalent law? If this the school or the secretary shall apply in compliance with the Supreme Court order. Now says prevalent law. Now whether he will apply as per the law prevailing in 1986 or in 2007.
Court is to decide, Your Lordship. That is to decide.
Now what is your interpretation?
My understanding is 2007.
How 2007?
Because Lord,
your understanding has to be supported with your submissions, na? What is your reasoning for that?
Lordship,
what my brother has said after this, what is your reasoning?
Well, my reason.
Anyway, let's not go into these sort of arguments. Let us pass our order. You test our order in Supreme Court.
এটাতে 30 লিখে দাও।
Come to page 62.
Item
62. Fact of the case.
Fact of the case.
The school was established in 86. But as nothing positive material, series of litigations complying with the directions of High Court, prayer of this was rejected twice by the board. এই যে twice করেছে, where are these two orders? You don't have. See how the matter is being. The prayer was first rejected. Vide order dated 27 February 1998. Again by 14 September 1998. Where are these two orders? Next, challenging such order, another writ petition was prepared 6748. That is Justice Indira Banerjee's order. So you show us the orders of rejection on 27 February 98 and 14 September 98. Now this inspection was conducted after 2007 order. Was there any inspection conducted? Is there any reference of any inspection in the earlier two rejected orders?
Inspection was made.
Earlier two orders, have you seen those orders at all?
It has not yet been annexed, my lord.
Well, one DLIT inspection report is page 39.
39 DLIT is of much later date.
1997.
So that is
1997.
39.
39.
So date of inspection is also prior to the regulations.
1997 rejected in 98. That means, my lord, on basis of the DLIT report, it has been rejected. Because after DLIT, it has been rejected. Maybe on the ground
It
of
is your
infrastructure.
regulation. Do you have 2007 regulation? That 2007 regulation is for the no financial assistance.
Yes. But after Control and Expenditure Act, the regulation has been amended.
সেই তো রেগুলেশনটা কোথায়? 2007 রেগুলেশন। আরে বাবা এগুলো কালেক্ট করতে হবে। এগুলো করে দিলে হলো না। You have to argue the matter.
I will satisfy your lordship. Kindly.
আর কবে স্যাটিসফাই করবে? We have.
Kindly fix this matter, my lord, on Friday, my lord. My lord, kindly give us 2 days time to satisfy your lordships.
Page 30.
39.
Where is Justice Division Bench order?
Division Bench order is page supplementary affidavit, page 12.
Yeah, but the supplementary
Page starting with page 10.
Supplementary evidence sub.
My lord,
How you are?
My lord, with due respect, with my lord, with due respect to my learned senior, every copy has been submitted. Everyone.
Show us the receipt
I
that
don't
you
have
have
it.
sub.
That is the reason I couldn't see all these orders.
We have filed affidavit on service, my lord.
আরে বলছে supplementary affidavit of service is there.
No. Supplementary appeal, stay, condonation of delay, and supplementary affidavit, my lord. The 4 parts have already been sent to all of them.
না না আমার কাছে শুধু
Then why she will
My lord, I will supply her.
That is I couldn't go through all these orders. That's a supplementary. The extra copy is a supplementary. Nothing.
now is your school functioning?
My lord.
What document do you have to show that your school is functioning?
As this honorable court,
What did you produce before the board that the school is functioning? Was anything written in that order?
Fresh DLIT টার হলো না as per Indira Banerjee। কারণ ওটা তো চ্যালেঞ্জ করবে না। হাতে করতে পারেন inspection
Evident lawyer.
ওরা কি অ্যাপ্লিকেশন করেছিল?
2007 Justice Banerjee
অর্ডারে ওরা এরা করেছিল? আন্ডার হুইচ ল?
They have not said that এই অ্যাপ্লিকেশন করে ছেড়ে দিয়েছে। সুপ্রিম কোর্ট বলে দিয়েছে তো প্রিভিলেন্ট লতে করবে। ওরা আর কি করে সুপ্রিম কোর্টের উপরে বলবে? Where is your representation after the Supreme Court order?
Yes, my lord, I'm coming.
Page 50.
Page 50.
50.
50.
Input after 2000.
They were held because they went to division bench. Because challenged the order of the fresh DLIT passed by Justice Banerjee, 2007.
Then what is this 2017-18 inquiry report? Ad hoc committee took note of that, an inquiry report of.
That is of the DI. That is not a DLIT.
Where is that? That also you don't have. Do you have that?
My lord,
This 23rd of 27th of August 2018. Do you have that?
my lord, it has already been taken note in their impugned order, my lord.
Do you have a copy of that?
Not now, it is with my senior, my lord.
চ্যালেঞ্জ করেছিল কেন কি
কোনটা?
এই যে 2005-এর ইয়েটা চ্যালেঞ্জ করলো কেন? একটা জিনিস 2005-এ যেটা ছিল যে
তো D97 এর
এই 98 সেটা সাইড করেনি তোমাকে কেউ করেনি বোধহয়।
My lord, after page 50, they approach before the honorable court. My lord, page 58. 58. Justice Saraf set aside that order. Again remanded back.
Oh,
My lord, page 58.
98 order, 98 order.
No. 2018. After filing the application before the board, then my lord, page 58. Justice Saraf's order.
Oh.
That is for Justice Sharaf said considered.
No. Since the Vishwanath Ghosh is not appeared in the time of hearing, so you pass a fresh order. My lord, page 59. Kindly come.
তারপরে এইটা এলো।
Then 62. টাইম নিয়ে নাও দাদা, ভালো করে প্রিপেয়ার্ড হয়ে।
একটু এগুলোর কি পার্থক্য একটু দেখলে ভালো। 86 এ যেটা প্রিভিলেন্স ছিল
86 এর যেটা প্রিভিলেন্স ছিল সেটা memo 27th February 98 and 14 September 98. These rejection orders, page 62. Ms. Bhattacharya, you must be having a file pertaining to this litigation. Your board file has to be there. Otherwise, how could the board mention the dates of those? Those documents must be in your.
Must be.
Huh?
Must
be in your.
Must be.
So you bring the original file to us.
May I file a report, Your Lordship, annexing those orders? I think that will be the order which has been referred by the board. These two rejections, my lord. If the rejections might be with them, because how they have now said over here, may I file a report annexing those particular documents? Because my lord, at that point of time, it was the recognition committee. And now all are gone. So, my lord, I don't think.
No, this matter was considered on 4th of October 2018.
No, recognition after 2011, the board became defunct. So, no committees now. After 2011, there is no board. All the committees of board are defunct. Now, ad hoc committee is running the board after 2011.
Till date?
Yes.
So there is no there is still an ad hoc
committee.
So
all the because this recognition committee, this 1998, when this rejection was done on basis of the document of the school education department, those were before the recognition committee of the board. So now the recognition committee, all are not there. Very difficult to find, because in other matters I have also asked, it's very difficult to find those papers. But Your Lordship, may direction may be given, Your Lordship, may I file a? And the DIA may also be having, because my lord, on basis of the DLIT report and on basis of the recommendation of the school education department, that point of the director of school education, so the board has passed the rejection order. So it must be also with DI also. Let me also file and he also files, so that if any document missing, we can get from each other.
The present appeal has been preferred. with copies to the learned advocates appearing for the state and the court. তারপরে
Matter will appear on 17th September.
2 weeks
December.
ইভেন্টারি 2 weeks করে সাপ্লাই করতে হলে যতক্ষণ ওটা করছে করবে না।
জানুয়ারি
আচ্ছা ও সাপ্লিমেন্টারি এভিডেভিট পিটিশন বাই ওই 15 ডিসেম্বর করে দেবে, হ্যাঁ? Please the matter for further consideration in the daily supplementary list of this court under the same heading on 17th December.
My lord, before your lordship right now. And then renew my prayer, my lord, your lordship will recollect that upon my mentioning that matter.
Mr. Agarwal, why you are mentioning so many times?
Well, because my lord, your lordship directed the matter to appear today, it has appeared. But it has gone down at 45.
It will be taken up.
My lord, interim order is only up to 15th. That's why your lordship pleasure was to direct that this matter will appear today. Interim order is
your other side.
Well, other side, Mr.
This way, Mr. Agarwal, we cannot give indulgence. Then you should have given a notice, asked your junior to mention.
I was expecting that it may be taken up, but it was not.
You are only saying it will not be reached. Then was it not your responsibility that let the junior serve a notice and come back? The interim order is going to expire on 15th.
On Friday, I have mentioned the matter Thursday, and I have informed the lordship, my lord, that the interim order is going to expire on 15th.
When you are such an emergency, we release the matter. What matter ta bolche?
My lord,
no, you this cannot continue. This way repeatedly we cannot be disturbed. Which is your matter, Mr. Agarwal? On personal ground of one of us, bole amar naam likhe dao. The matter, kun matter?
My lord, you will not release. Otherwise, my lord, interim order.
Mr. Agarwal, this is not the system. It sends bad signals.
My lord,
we never allow councils to mention except from the with prior notice. And you are a senior member. We accepted your.
This matter was mentioned upon prior notice, my lord. But only because this is not taken up today, my lord, that's why I am beseeching your lordship. Anyway, my lord, I shall give notice, then I shall come.
So which is your matter? Tell us.
Item 45, my lord. Group 8, only one matter is.
এরকম ভাবে mention করে না. This sends back signals as if we are allowing mentioning of Mr. Agarwal and not listening to other bodies. Nowadays, we are on the fault finding basis. No. The live streaming is going on. Tomorrow, the advocate will come and say this. Mr. Sahadai knows also.
My lord, your lordship, on the last.
This is our problem.
Lord,
whatever we say, that is bad. But what the councils are doing, nobody is bothered.
My lord, it will not take me amiss, my lord. This is not the thing, my lord.
High time to take you amiss. Try your luck, Mr. Agarwal, in other court. What is your problem?
Only again, then, my lord, if it is not, I shall mention upon notice on Thursday when your lordship will take him, because it is the last date is on Friday, my lord.
দেখি ফাইলটা বের করো when it is expiring, let us see. চাপিয়ে দিয়ে where is your interim order?
Well, that final order where the
Sir, any order passed by the appeal court? Any order passed by
not by the appeal court, madam.
interim order you say?
Learned trial judge has given time only up to 15th.
15th of you are preferring a leave to appeal?
No, my lord. This is appeal again the final order.
Then why you are saying interim order is going to expire?
My lord, interim order by the learned trial judge to deposit only up to 15th.
Of suspension passed by the learned subdivisional controller.
My lord, kindly come to page 227. Paragraph 28, my lord. That's why, my lord, that is only urgency.
Yes, that's why what happened? Don't deposit your suspension. You are under suspension.
I am suspended.
So your suspension has been suspended. So it will revive. Let it revive.
No, my lord, there are two things. One is imposition of penalty. One is suspension. Suspension has been directed to be revived after 15th if I do not deposit. But if I do not deposit 15, then other steps may be taken by them. That is the only thing, my lord. Suspension is still continuing. Suspension is, there is no scope of revival. Amount of, my lord, that is harsh amount has been.
This way, Mr. Agarwal.
My lord, I appreciate, my lord, I appreciate, my lord.
আজকে কত তারিখ? আজকে কত তারিখ? 10 তারিখ।
আজ ডিপোজিট করেছে।
We were wondering as to whether any coordinate bench has passed
No
an
coordinate,
interim order.
my lord. This is the first time it has appeared. I am saying, I just tell you, my lord, that 15 is the last date for payment of the fine.
You will say what we cannot quarrel with you. Whatever you have
And
said,
that is the interim order is that suspension will revive after 15.
This way it cannot. If it revives. So
Then, my lord,
appeal court is in CC of the matter.
Supreme Court is not in CC.
Appeal court is in CC.
Yes, your lordship, my lord.
And if they revive, let that do at their risk and cost.
There is an order, my lord, and they have said.
We are liberal in allowing mentioning everyday people walking and mentioning this fashion. We are telling you.
My lord, I won't mention, my lord. Let it go. Then I shall mention upon notice on Thursday. Let it be, my lord. Kindly grant me liberty to mention it on Thursday because there is still one day. Now, I do not want to kiss your lordship, my lord.
You have already said this is the third time you are mentioning Mr. Agarwal.
My lord,
this is the third time.
Yes, my lord. I say, my lord.
Your matter is not the only important matter in
No,
High Court,
definitely
Mr.
not.
Agarwal.
Definitely.
It sends bad signals. You were mentioning at the time of rising, we didn't see you in court for the entire morning. You didn't show us in the morning also.
Well, in the morning, since it was 45, I too did not come.
You have a junior, Mr. Agarwal?
My lord, my junior was here, my lord.
Where was your junior?
Well, he was here.
This matter was not mentioned.
No, not mentioned, my lord.
Then you could have told us, sir.
What is the amount? What is the amount?
7 crores 89 lakhs. For a small dealer whose earning is 10-15,000 rupees. And that was stayed by the learned trial judge initially.
Give a notice to your other side, mention tomorrow.
My
Notices, no, not give
my
day
I shall-
after tomorrow. You mention.
My lord, your launching date is Thursday. I shall mention it on Thursday.
No. We have taken notice. You are mentioning, we will ascertain what is so much of urgency in the matter. We will consider on that day. Give notice. If
shall give-
15th you have said, we will hear it prior to 15th. We will hear it prior to 15th.
Yeah.
Yes, mention day after tomorrow. We will keep considered there.
My lord will not be angry.
Well, we are very annoyed.
My
This
lord-
should not be the process.
My
Since we respect our elders, that does not mean that the elder will